Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Moore v. Harper. In this case, the court considered this issue. Under the U.S. Constitution, does the state legislative body, independent of any constraints by state courts or other laws, have sole authority to regulate federal elections? The case was decided on June 27, 2023. The Supreme Court held that the Federal Elections Clause does not vest exclusive and independent authority in state legislatures to set the rules regarding federal elections. Chief Justice John Roberts authored the 6-3 majority opinion of the court. First, the court confirmed that it had jurisdiction to review the case. The North Carolina Supreme Court's decision to overrule its previous judgment did not moot the case, because there remains a live dispute between the parties. Second, the court concluded that the Elections Clause does not grant state legislatures exclusive authority to regulate federal elections. Judicial review has been an accepted practice since Marbury v. Madison, and under the court's precedents, the Elections Clause authority of state legislatures is subject to checks and balances provided by the state constitution. State legislatures are not wholly independent bodies, and they are bound by the constraints imposed by the state constitutions. Third, state courts have the authority to interpret state laws affecting federal elections, but they cannot sidestep federal law. The court declined to decide whether the North Carolina Supreme Court in this case overstepped its authority, because that issue was not properly before it. Justice Brett Kavanaugh authored a concurring opinion noting that while the court need not answer the question of which standard a federal court should employ to review a state court's interpretation of state law in a case implicating the Elections Clause, there are three standards from which to choose that all convey the same point: deference but not abdication. Justice Clarence Thomas authored a dissenting opinion, in which Justices Neil Gorsuch and Samuel Alito joined, arguing that the question presented in the case was moot, and that the writ of certiorari should be dismissed. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Chief Justice Roberts delivered the opinion of the court. Several groups of plaintiffs challenged North Carolina's congressional districting map as an impermissible partisan gerrymander. The plaintiffs brought claims under North Carolina's Constitution, which provides that all elections shall be free. Relying on that provision as well as the state constitution's equal protection, free speech, and free assembly clauses, the North Carolina Supreme Court found in favor of the plaintiffs and struck down the legislature's map. The court concluded that North Carolina's legislature deliberately drew the state's congressional map to favor Republican candidates. In drawing the state's congressional map, North Carolina's legislature exercised authority under the Elections Clause of the federal Constitution, which expressly requires the legislature of each state to prescribe the times, places, and manner of federal elections. We decide today whether that clause vests state legislatures with authority to set rules governing federal elections free from restrictions imposed under state law. The Elections Clause provides, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The clause imposes on state legislatures the duty to prescribe rules governing federal elections. It also guards against the possibility that a state would refuse to provide for the election of representatives by authorizing Congress to prescribe its own rules. The 2020 decennial census showed that North Carolina's population had increased by nearly 1 million people, entitling the state to an additional seat in its federal congressional delegation. Following those results, North Carolina's General Assembly set out to redraw the state's congressional districts. The General Assembly also drafted new maps for the state's legislative districts, including the State House and the State Senate. In November 2021, the Assembly enacted 3 new maps, each passed along party lines. Shortly after the new maps became law, several groups of plaintiffs, including the North Carolina League of Conservation Voters, Common Cause, and individual voters, sued in state court. The plaintiffs asserted that each map constituted an impermissible partisan gerrymander, in violation of the North Carolina Constitution. At trial before a 3-judge panel of the Wake County Superior Court, the plaintiffs presented expert testimony and other evidence to support their claims that North Carolina's General Assembly drew state legislative and federal congressional maps to favor Republican candidates. The trial court agreed, finding that the General Assembly's 2021 congressional districting map was a partisan outlier intentionally and carefully designed to maximize Republican advantage in North Carolina's congressional delegation. But the court denied relief, reasoning that the partisan gerrymandering claims amounted to political questions that are non-justiciable under the North Carolina Constitution. The North Carolina Supreme Court reversed, holding that the legislative defendants violated state law beyond a reasonable doubt by enacting maps that constituted partisan gerrymanders. It also rejected the trial court's conclusion that partisan gerrymandering claims present a non-justiciable political question. The court acknowledged our decision in Rucho v. Common Cause, which held that partisan gerrymandering claims present political questions beyond the reach of the federal courts. But simply because the Supreme Court has concluded partisan gerrymandering claims are non-justiciable in federal courts, the court explained, it does not follow that they are non-justiciable in North Carolina courts. The state Supreme Court also rejected the argument that the Elections Clause in the federal Constitution vests exclusive and independent authority in state legislatures to draw congressional maps. After holding that the 2021 districting maps substantially infringe upon plaintiffs' fundamental right to equal voting power, the court struck down the maps and remanded the case to the trial court to oversee the redrawing of the maps by the General Assembly or, if necessary, by the court. The court entered judgment on February 15, 2022. 2 days later, the General Assembly adopted a remedial congressional redistricting plan, but the trial court rejected that plan and adopted in its place interim maps developed by several special masters for use in the 2022 North Carolina congressional elections. On February 25, 2022, the legislative defendants filed an emergency application in this court, citing the Elections Clause and requesting a stay of the North Carolina Supreme Court's decision. We declined to issue emergency relief but later granted certiorari. Following our grant of certiorari, the North Carolina Supreme Court heard an appeal concerning the trial court's remedial order. In December 22, the court issued a decision affirming in part, reversing in part, and remanding the case. As relevant, it agreed with the trial court's determination that the General Assembly's remedial congressional plan fell short of the requirements set forth in Harper I. The legislative defendants sought rehearing, requesting that the North Carolina Supreme Court withdraw its remedial opinion in Harper II. They also asked the court to overrule its decision in Harper I, although they conceded that doing so would not negate the force of its order striking down the 2021 plans. The North Carolina Supreme Court granted rehearing in Harper II, and we ordered the parties to submit supplemental briefing concerning our jurisdiction over this case in light of that decision. Following the parties' submission of supplemental briefs in this court, the North Carolina Supreme Court issued a decision granting the requests made by the legislative defendants. The court withdrew its opinion in Harper II concerning the remedial maps and overruled its decision in Harper I, relying on our decision in Rucho, and on a renewed look at the constitutional provisions at issue. The court repudiated Harper I's conclusion that partisan gerrymandering claims are justiciable under the North Carolina Constitution. The North Carolina Supreme Court dismissed the plaintiffs' claims with prejudice, but it did not reinstate the 2021 congressional plans that Harper I had struck down under the North Carolina Constitution. Instead, the court provided the General Assembly with the opportunity to enact a new set of legislative and congressional redistricting plans, guided by federal law, the objective constraints in Article 2, Sections 3 and 5 of the North Carolina Constitution, and this opinion. The court did not revisit Harper I's conclusion that the Federal Elections Clause does not shield state legislatures from review by state courts for compliance with state constitutional provisions. The General Assembly exercises redistricting authority subject to the express limitations in our Constitution and in federal law. We invited the parties to submit additional supplemental briefs addressing the effect of the court's decision on our jurisdiction. Before turning to the merits, we must determine as a threshold matter that we have jurisdiction. The Constitution provides for our jurisdiction over cases and controversies. That constitutional requirement ensures that the parties before us retain a personal stake in the litigation. As a corollary to this case or controversy requirement, there must exist a dispute at all stages of review, not merely at the time the complaint is filed. Mootness doctrine addresses whether an intervening circumstance has deprived the plaintiff of a personal stake in the outcome of the lawsuit. The North Carolina Supreme Court's decision to withdraw Harper II and overrule Harper I does not moot this case. The plaintiffs here sought to enjoin the use of the 2021 plans enacted by the legislative defendants. Harper I granted that relief, and in doing so rejected the Elections Clause defense at issue before us. Prior to both the appeal and rehearing proceedings in Harper II, the North Carolina Supreme Court had already entered the judgment and issued the mandate in Harper I, and the time during which the defendants could seek rehearing as to that judgment had long since passed. Recognizing this reality, the legislative defendants did not ask the North Carolina Supreme Court to disturb the judgment in Harper I as part of the rehearing proceedings. They instead acknowledged that they would remain bound by Harper I's decision enjoining the use of the 2021 plans. The North Carolina Supreme Court overruled Harper I, thereby granting the specific relief requested by the legislative defendants. As a result, partisan gerrymandering claims are no longer justiciable under the state's constitution. But although the defendants may now draw new congressional maps, they agree that the North Carolina Supreme Court overruled only the reasoning of Harper I, and did not disturb its judgment nor alter the presently operative statutes of North Carolina. In other words, although partisan gerrymandering claims are no longer viable under the North Carolina Constitution, the North Carolina Supreme Court has done nothing to alter the effect of the judgment in Harper I enjoining the use of the 2021 maps. As a result, the legislative defendant's path to complete relief runs through this court. Were we to reverse the judgment in Harper I, a step not taken by the North Carolina Supreme Court, the 2021 plans enacted by the legislative defendants would again take effect. The parties accordingly continue to have a personal stake in the ultimate disposition of the lawsuit. A North Carolina statute with specific application to this proceeding confirms that the controversy before us remains live. Under state law, if the United States Supreme Court reverses the decision in Harper I, the 2021 maps will again become effective. We have previously found such trigger provisions, in North Carolina no less, sufficient to avoid mootness under Article 3. We also have jurisdiction to review the judgment in Harper I under federal law. That statute provides for this court's exercise of jurisdiction over final judgments or decrees rendered by the highest court of a state, in which a decision could be had. We have, however, recurringly encountered situations in which the highest court of a state has finally determined the federal issue present in a particular case, but in which there are further proceedings in the lower state courts to come. Cox Broadcasting delineated at least 4 categories of such cases, in which the court has treated the decision on the federal issue as a final judgment for the purposes of federal law, despite additional proceedings anticipated in the lower state courts. As relevant, the second category includes those cases in which the federal issue, finally decided by the highest court in the state, will survive and require decision regardless of the outcome of future state court proceedings. Harper I fits within this second category of cases described in Cox Broadcasting. By striking down the 2021 congressional plans enacted by the General Assembly, Harper I finally decided the federal issue whether the Elections Clause insulates state legislatures from review by state courts for compliance with state law. That issue both has survived and requires decision because subsequent proceedings have neither altered Harper I's analysis of the federal issue nor negated the effect of its judgment striking down the 2021 plans. In its decision overruling Harper I, the North Carolina Supreme Court in fact reaffirmed that it retains the authority to review congressional districting plans for compliance with state law. That the North Carolina Supreme Court overruled Harper I does not affect the judgment in that case for purposes of federal law. The res judicata consequences of a final, unappealed judgment on the merits are not altered by the fact that the judgment may have been wrong, or rested on a legal principle subsequently overruled in another case. The North Carolina Supreme Court has said much the same. An erroneous or irregular judgment binds the parties thereto until corrected in a proper manner. That court did not purport to alter or amend in any way the judgment in Harper I. In short, the record before us shows that Harper I finally decided the Elections Clause issue, which has survived subsequent proceedings in the North Carolina Supreme Court, such that it continues to require decision by this court. Justice Thomas sees it differently. He correctly observes that the North Carolina Supreme Court has now dismissed the plaintiff's claims with prejudice. He posits, therefore, that the legislative defendants are not injured by the judgment of Harper I. But the record before us belies that notion. Harper I enjoined the use of the 2021 maps in subsequent elections in North Carolina. Well, after the time for seeking rehearing as to that judgment passed, the legislative defendants instead sought rehearing with respect to Harper II, a distinct decision concerning remedies. The defendants steadfastly maintained in rehearing proceedings before the North Carolina Supreme Court that overruling Harper I would not negate the force of its order striking down the 2021 plans. With those concessions on the record, the North Carolina Supreme Court issued its decision overruling Harper I, and, by contrast, withdrawing its decision in Harper II. And mirroring their representations before the North Carolina Supreme Court, the legislative defendants now maintain in this court that they continue to remain bound by the judgment in Harper I. In an effort to cast doubt on these consistent representations by the injured party before us, Justice Thomas contends that the legislative defendants have already received complete relief, because nothing now prevents the implementation of the 2021 maps. For the reasons stated above, that would come as a surprise to both the legislative defendants and the North Carolina Supreme Court. The dissent also emphasizes that several of the plaintiffs contest our jurisdiction, but that has been their position from the very beginning, and it did not prevent our granting certiorari. The concessions offered by the legislative defendants as part of the rehearing proceedings, the recent opinion issued by the North Carolina Supreme Court, and the legislative defendants' briefing in this court all tell the same story. Harper I continues to enjoin the use of the 2021 maps. Following the dissents, logic and dismissing this case as moot would foreclose the one path to full relief available to the legislative defendants, a decision by this court reversing the judgment in Harper I. This court has before it a judgment issued by a state's highest court that adjudicates a federal constitutional issue. The defendants did not ask the North Carolina Supreme Court to vacate that judgment, That court did not purport to do so, and the defendants now concede that they remain bound by it. Cox Broadcasting considered our exercise of jurisdiction where the federal issue will survive and require decision regardless of the outcome of future state court proceedings. Unlike cases in which we must anticipate what the future might hold, we now know the resolution of the anticipated state court proceedings. The record shows that Harper I finally decided the Elections Clause question. The judgment in that case continues to bind the parties before us, and the 2021 congressional maps would again take effect in North Carolina were we to reverse. Accordingly, we have jurisdiction under both Article 3 and federal law. The question on the merits is whether the Elections Clause insulates state legislatures from review by state courts for compliance with state law. Since early in our nation's history, courts have recognized their duty to evaluate the constitutionality of legislative acts. We announced our responsibility to review laws that are alleged to violate the federal Constitution in Marbury v. Madison, proclaiming that it is emphatically the province and duty of the Judicial Department to say what the law is. Marbury confronted and rejected the argument that Congress may exceed constitutional limits on the exercise of its authority. Certainly all those who have framed written constitutions, we reasoned, contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of every such government must be that an act of the legislature, repugnant to the Constitution, is void. Marbury proclaimed our authority to invalidate laws that violate the federal Constitution, but it did not fashion this concept out of whole cloth. Before the Constitutional Convention convened in the summer of 1787, a number of state courts had already moved in isolated but important cases to impose restraints on what the legislatures were enacting as law. Although judicial review emerged cautiously, it matured throughout the founding era. These state court decisions provided a model for James Madison, Alexander Hamilton, and others who would later defend the principle of judicial review. In the 1786 case Trevett v. Whedon, for example, lawyer James Varnum challenged a Rhode Island statute on the ground that it failed to provide the right to a jury trial. Although Rhode Island lacked a written constitution, Varnum argued that the state nevertheless had a constitution reflecting the basic historical rights of the English. And, he contended, the courts must honor the principles of the Constitution in preference to any acts of the General Assembly. Varnum won, to the dismay of the state's legislature, which replaced 4 of the 5 judges involved. His arguments were published as a pamphlet, which may well have been the most prominent discussion of judicial review at the time of the Philadelphia Constitutional Convention. The North Carolina Supreme Court played its own part in establishing judicial review. In Bayard v. Singleton, the court considered the constitutionality of a 1785 act by the state's General Assembly that prevented British loyalists from challenging property seizures before a jury. The court held the act abrogated and without any effect, for it was clear that the legislature could not pass an act that could by any means repeal or alter the Constitution. Otherwise, the legislature would at the same instant of time destroy their own existence as a legislature, and dissolve the government thereby established. James Iredell, who would later serve as an inaugural justice of this court, penned at the time an open letter to the public expounding a robust concept of judicial review. The power of the Assembly, he wrote, is limited and defined by the Constitution. The legislature, after all, is a creature of the Constitution. North Carolina and Rhode Island did not stand alone. All told, state courts in at least 7 states invalidated state or local laws under their state constitutions before 1787, which laid the foundation for judicial review. The framers recognized state decisions exercising judicial review at the Constitutional Convention of 1787. On July 17, James Madison spoke in favor of a federal council of revision that could negate laws passed by the states. He lauded the Rhode Island judges who refused to execute an unconstitutional law, lamenting that the state's legislature then displaced them to substitute others who would be willing instruments of the wicked and arbitrary plans of their masters. A week later, Madison extolled as one of the key virtues of a constitutional system that a law violating a constitution established by the people themselves would be considered by the judges as null and void. Elbridge Gerry, a delegate from Massachusetts, also spoke in favor of judicial review. At the convention, he noted that in some states the judges had actually set aside laws as being axed the Constitution. Such judicial review, he noted, was met with general approbation. Writings in defense of the proposed Constitution echoed these comments. In the Federalist Papers, Alexander Hamilton maintained that courts of justice have the duty to declare all acts contrary to the manifest tenor of the Constitution void. This doctrine of judicial review, he also wrote, was equally applicable to most, if not all, the state governments. State cases, debates at the convention, and writings defending the Constitution all advanced the concept of judicial review. And in the years immediately following ratification, courts grew assured of their power to void laws incompatible with constitutional provisions. The idea that courts may review legislative action was so long and well established by the time we decided Marbury in 1803 that Chief Justice Marshall referred to judicial review as one of the fundamental principles of our society. We are asked to decide whether the Elections Clause carves out an exception to this basic principle. We hold that it does not. The Elections Clause does not insulate state legislatures from the ordinary exercise of state judicial review. We first considered the interplay between state constitutional provisions and a state legislature's exercise of authority under the Elections Clause in Ohio ex rel. Davis v. Hildebrandt. There, we examine the application to the Elections Clause of a provision of the Ohio Constitution permitting the state's voters to approve or disapprove by popular vote any law enacted by the General Assembly. In 1915, the Ohio General Assembly drew new congressional districts, which the state's voters then rejected through such a popular referendum. Asked to disregard the referendum, the Ohio Supreme Court refused, explaining that the Elections Clause, while conferring the power therein defined upon the various state legislatures, did not preclude subjecting legislative acts under the clause to a popular vote. We unanimously affirmed, rejecting as plainly without substance, the contention that to include the referendum within state legislative power for the purpose of apportionment is repugnant to Section 4 of Article 1, the Elections Clause. Smiley v. Home, decided 16 years after Hildebrandt, considered the effect of a governor's veto of a state redistricting plan. Following the 15th decennial census in 1930, Minnesota lost one seat in its federal congressional delegation. The state's legislature divided Minnesota's then 9 congressional districts in 1931, and sent its act to the governor for his approval. The governor vetoed the plan pursuant to his authority under the state's constitution. But the Minnesota Secretary of State nevertheless began to implement the legislature's map for upcoming elections. A citizen sued, contending that the legislature's map was a nullity and that, after the governor's veto, it was not repassed by the legislature as required by law. The Minnesota Supreme Court disagreed. In its view, the authority so given by the Elections Clause is unrestricted, unlimited, and absolute. The Elections Clause, it held, conferred upon the legislature the exclusive right to redistrict such that its actions were beyond the reach of the judiciary. We unanimously reversed. A state legislature's exercise of authority under the Elections Clause, we held, must be in accordance with the method which the state has prescribed for legislative enactments. Nowhere in the federal Constitution could we find provision of an attempt to endow the legislature of the state with power to enact laws in any manner other than that in which the Constitution of the state has provided that laws shall be enacted. Smiley relied on founding-era provisions, constitutional structure, and historical practice, each of which we found persuasive. 2 states at the time of the founding provided a veto power, restrictions that were well known. Subjecting state legislatures to such a limitation was no more incongruous with the grant of legislative authority to regulate congressional elections than the fact that the Congress in making its regulations under the same provision would be subject to the veto power of the President. And long and continuous interpretation as evidenced by the established practice in the states provided further support. We noted that many state constitutions had adopted provisions allowing for executive vetoes, and that the uniform practice has been to provide for congressional districts by the enactment of statutes with the participation of the governor wherever the state constitution provided for such participation. This court recently reinforced the teachings of Hildebrandt and Smiley in a case considering the constitutionality of an Arizona ballot initiative. Voters amended Arizona's constitution to remove redistricting authority from the Arizona legislature and vest that authority in an independent commission. The Arizona legislature challenged a congressional map adopted by the commission, arguing that the Elections Clause precludes resort to an independent commission to accomplish redistricting. A divided court rejected that argument. The majority reasoned that dictionaries of the founding era capaciously defined the word legislature, and concluded that the people of Arizona retained the authority to create an alternative legislative process by vesting the lawmaking power of redistricting in an independent commission. The court ruled, in short, that although the Elections Clause expressly refers to the legislature, it does not preclude a state from vesting congressional redistricting authority in a body other than the elected group of officials who ordinarily exercise lawmaking power. States, the court explained, retain autonomy to establish their own governmental processes. The significant point for present purposes is that the court in Arizona state legislature recognized that whatever authority was responsible for redistricting, that entity remained subject to constraints set forth in the state constitution. The court embraced the core principle espoused in Hildebrandt and Smiley that redistricting is a legislative function, to be performed in accordance with the state's prescriptions for lawmaking, which may include the referendum and the governor's veto. The court dismissed the argument that the Elections Clause divests state constitutions of the power to enforce checks against the exercise of legislative power. Nothing in the Elections Clause instructs, nor has this court ever held, that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. The reasoning we, unanimously embraced in Smiley, commands our continued respect. A state legislature may not create congressional districts independently of requirements imposed by the state constitution with respect to the enactment of laws. The legislative defendants and the dissent both contend that, because the federal constitution gives state legislatures the power to regulate congressional elections, only that constitution can restrain the exercise of that power. The legislative defendants cite for support Federalist No. 78, which explains that the wielding of legislative power is constrained by the tenor of the commission under which it is exercised. This argument simply ignores the precedent just described. Each rejected the contention that the Elections Clause vests state legislatures with exclusive and independent authority when setting the rules governing federal elections. The argument advanced by the defendants and the dissent also does not account for the framers' understanding that when legislatures make laws, they are bound by the provisions of the very documents that give them life. Legislatures, the framers recognized, are the mere creatures of the state constitutions, and cannot be greater than their creators. What are legislatures? Creatures of the Constitution. They owe their existence to the Constitution. They derive their powers from the Constitution. It is their commission, and, therefore, all their acts must be conformable to it, or else they will be void. This understanding was confirmed, and nothing in the text of the Elections Clause undermines it. When a state legislature carries out its constitutional power to prescribe rules regulating federal elections, the commission under which it exercises authority is twofold. The legislature acts both as a lawmaking body created and bound by its state constitution, and as the entity assigned particular authority by the federal constitution. Both constitutions restrain the legislature's exercise of power. Turning to our precedents, the defendants quote from our analysis of the Electors Clause. That clause, similar to the Elections Clause, provides that each state shall appoint, in such manner as the legislature thereof may direct, a specified number of electors. Considered a challenge to the Michigan legislature's decision to allocate the state's electoral votes among the individual congressional districts, rather than to the state as a whole. We upheld that decision, explaining that in choosing presidential electors, the clause leaves it to the legislature exclusively to define the method of effecting the object. Our decision in this case, however, had nothing to do with any conflict between provisions of the Michigan Constitution and action by the state's legislature, the issue we confront today. Instead, we considered whether Michigan's legislature itself directly violated the Electors Clause by taking from the state the power to appoint and vesting that power in separate districts, the 14th Amendment, by allowing voters to vote for only one elector rather than electors, and a particular federal statute. Nor does the quote highlighted by petitioners tell the whole story. Chief Justice Fuller's opinion for the court explained that the legislative power is the supreme authority except as limited by the Constitution of the state. The legislative defendants and Justice Thomas rely as well on our decision, but it too offers little support. Addressed an argument that the 19th Amendment, providing women the right to vote, was invalid because state constitutional provisions rendered inoperative the alleged ratifications by their legislatures. We rejected that position, holding that when state legislatures ratify amendments to the Constitution, they carry out a federal function derived from the federal Constitution, which transcends any limitations sought to be imposed by the people of a state. But the legislature in this case performed a ratifying function rather than engaging in traditional lawmaking. The provisions at issue in today's case, like the provisions examined, concern a state legislature's exercise of lawmaking power. And as we held, when state legislatures act pursuant to their Elections Clause authority, they engage in lawmaking subject to the typical constraints on the exercise of such power. We have already distinguished this on those grounds. In addition, cited for support our decision which sharply separated ratification from legislative action under the Elections Clause. Lawmaking under the Elections Clause, this explained, is entirely different from the requirement of the Constitution as to the expression of assent or dissent to a proposed amendment to the Constitution. These cases delineated the various roles that the Constitution assigns to state legislatures. Legislatures act as consenting bodies when the nation purchases land, as ratifying bodies when they agree to proposed constitutional amendments, and, prior to the passage of the 17th Amendment, as electoral bodies when they choose United States senators. By fulfilling their constitutional duty to craft the rules governing federal elections, state legislatures do not consent, ratify, or elect. They make laws. Elections are complex affairs, demanding rules that dictate everything from the date on which voters will go to the polls to the dimensions and font of individual ballots. Legislatures must provide a complete code for congressional elections, including regulations relating to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In contrast, a simple up or down vote suffices to ratify an amendment to the Constitution. Providing consent to the purchase of land or electing senators involves similarly straightforward exercises of authority. But fashioning regulations governing federal elections unquestionably calls for the exercise of lawmaking authority. And the exercise of such authority in the context of the Elections Clause is subject to the ordinary constraints on lawmaking in the state constitution. In sum, our precedents have long rejected the view that legislative action under the Elections Clause is purely federal in character, governed only by restraints found in the federal Constitution. Addressing our decisions in Smiley and Hildebrandt, both the legislative defendants and Justice Thomas concede that at least some state constitutional provisions can restrain a state legislature's exercise of authority under the Elections Clause. But they read those cases to differentiate between procedural and substantive constraints. Smiley, in their view, stands for the proposition that state constitutions may impose only procedural hoops through which legislatures must jump in crafting rules governing federal elections. This conceitedly formalistic approach views the governor's veto at issue in Smiley as one such procedural restraint. But when it comes to substantive provisions, their argument goes, our precedents have nothing to say. This argument adopts too cramped a view of our decision in Smiley. Chief Justice Hughes's opinion for the court drew no distinction between procedural and substantive restraints on lawmaking. It turned on the view that state constitutional provisions apply to a legislature's exercise of lawmaking authority under the Elections Clause, with no concern about how those provisions might be categorized. The same goes for the court's decision in Arizona State Legislature. The defendants attempt to cabin that case by arguing that the court did not address substantive limits on the regulation of federal elections. But as in Smiley, the court's decision in Arizona State Legislature discussed no difference between procedure and substance. The dissent reads Smiley and Arizona State Legislature in a different light. Justice Thomas thinks those cases say nothing about whether a state can impose substantive limits on the legislature's exercise of power under the Elections Clause. But in Smiley, we addressed whether the conditions which attach to the making of state laws apply to legislatures exercising authority under the Elections Clause. We held that they do. Much that is urged in argument with regard to the meaning of the term legislature, we explained, is beside the point, and we concluded in straightforward terms that legislatures must abide by restrictions imposed by state constitutions when exercising the lawmaking power under the Elections Clause. Arizona State Legislature said much the same, emphasizing that, by its text, nothing in the Elections Clause offers state legislatures carte blanche to act in defiance of provisions of the state's constitution. The defendants and Justice Thomas do not in any event offer a defensible line between procedure and substance in this context. The line between procedural and substantive law is hazy. Many rules are rationally capable of classification as either. Procedure, after all, is often used as a vehicle to achieve substantive ends. When a governor vetoes a bill because of a disagreement with its policy consequences, has the governor exercised a procedural or substantive restraint on lawmaking? Smiley did not endorse such murky inquiries into the nature of constitutional restraints, and we see no neat distinction today. Were there any doubt, historical practice confirms that state legislatures remain bound by state constitutional restraints when exercising authority under the Elections Clause. We have long looked to settled and established practice to interpret the Constitution, and we have found historical practice particularly pertinent when it comes to the Elections and Electors Clauses. Two state constitutional provisions adopted shortly after the founding offer the strongest evidence. Delaware's 1792 Constitution provided that the state's congressional representatives shall be voted for at the same places where representatives in the state legislature are voted for, and in the same manner, even though the Elections Clause stated that the places and manner of federal elections shall be prescribed by the state legislatures. The Delaware Constitution expressly enacted rules governing the places and manner of holding elections for federal office. An 1810 amendment to the Maryland Constitution likewise embodied regulations falling within the scope of the Elections and Electors Clauses. Article 14 provided that every qualified citizen shall vote, by ballot, for electors of the President and Vice President of the United States, and for representatives of this state in the Congress of the United States. If the Elections Clause had vested exclusive authority in state legislatures, unchecked by state courts enforcing provisions of state constitutions, these clauses would have been unenforceable from the start. Besides the two specific provisions in Maryland and Delaware, multiple state constitutions at the time of the founding regulated federal elections by requiring that all elections shall be by ballot. These provisions directed the manner of federal elections within the meaning of the Elections Clause, as Madison himself explained at the Constitutional Convention. The legislative defendants discount this evidence. They argue that those by-ballot provisions spoke only to the offices that were created by state constitutions, and not to the federal offices to which the Elections Clause applies. We find no textual hook for that strained reading. All meant then what it means now. In addition, the framers did not write the Elections Clause on a blank slate. They instead borrowed from the Articles of Confederation, which provided that delegates shall be annually appointed in such manner as the legislature of each state shall direct. The two provisions closely parallel, and around the time the Articles were adopted by the Second Continental Congress, multiple states regulated the manner of appointing delegates, suggesting that the framers did not understand that language to insulate state legislative action from state constitutional provisions. The defendants stress an 1820 convention held in Massachusetts to amend the Commonwealth's constitution. After a Boston delegate proposed a provision regulating the manner of federal elections, Joseph Story, then a justice of this court, nixed the effort. In Story's view, such a provision would run afoul of the Elections Clause by assuming a control over the legislature, which the Constitution of the United States does not justify. But Story's comment elicited little discussion, and reflects the views of a jurist who, although a brilliant and accomplished man, was not a member of the founding generation. Although we conclude that the Elections Clause does not exempt state legislatures from the ordinary constraints imposed by state law, state courts do not have free rein. State courts are the appropriate tribunals for the decision of questions arising under their local law, whether statutory or otherwise. At the same time, the Elections Clause expressly vests power to carry out its provisions in the legislature of each state, a deliberate choice that this court must respect. As in other areas where the exercise of federal authority or the vindication of federal rights implicates questions of state law, we have an obligation to ensure that state court interpretations of that law do not evade federal law. State law, for example, is one important source for defining property rights. At the same time, the federal Constitution provides that private property shall not be taken for public use, without just compensation. As a result, states may not sidestep the Takings Clause by disavowing traditional property interests. A similar principle applies with respect to the Contracts Clause, which provides that no state shall pass any law impairing the obligation of contracts. In that context, we accord respectful consideration and great weight to the views of the state's highest court. Still, in order that the constitutional mandate may not become a dead letter, we are bound to decide for ourselves whether a contract was made. Cases raising the question whether adequate and independent grounds exist to support a state court judgment involve a similar inquiry. We have in those cases considered whether a state court opinion below adopted novel reasoning to stifle the vindication in state courts of federal constitutional rights. Running through each of these examples is the concern that state courts might read state law in such a manner as to circumvent federal constitutional provisions. Therefore, although mindful of the general rule of accepting state court interpretations of state law, we have tempered such deference when required by our duty to safeguard limits imposed by the federal Constitution. Members of this court last discussed the outer bounds of state court review in the present context in Bush v. Gore. Our decision in that case turned on an application of the Equal Protection Clause of the 14th Amendment. In separate writings, several justices addressed whether Florida's Supreme Court, in construing provisions of Florida statutory law, exceeded the bounds of ordinary judicial review to an extent that its interpretation violated the Electors Clause. Chief Justice Rehnquist, joined in a concurring opinion by Justice Thomas and Justice Scalia, acknowledged the usual deference we afford state court interpretations of state law, but noted areas in which the Constitution requires this court to undertake an independent, if still deferential analysis of state law. He declined to give effect to interpretations of Florida election laws by the Florida Supreme Court that impermissibly distorted them beyond what a fair reading required. Justice Souter, for his part, considered whether a state court interpretation transcends the limits of reasonable statutory interpretation, to the point of supplanting the statute enacted by the legislature within the meaning of Article 2. We do not adopt these or any other test by which we can measure state court interpretations of state law in cases implicating the Elections Clause. The questions presented in this area are complex and context-specific. We hold only that state courts may not transgress the ordinary bounds of judicial review, such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. We decline to address whether the North Carolina Supreme Court strayed beyond the limits derived from the Elections Clause. The legislative defendants did not meaningfully present the issue in their petition for certiorari or in their briefing, nor did they press the matter at oral argument. Counsel for the defendants expressly disclaimed the argument that this court should reassess the North Carolina Supreme Court's reading of state law. When pressed whether North Carolina's Supreme Court did not fairly interpret its state constitution, Counsel reiterated that such an argument was not our position in this court. Although counsel attempted to expand the scope of the argument in rebuttal, such belated efforts do not overcome prior failures to preserve the issue for review. State courts retain the authority to apply state constitutional restraints when legislatures act under the power conferred upon them by the Elections Clause, but federal courts must not abandon their own duty to exercise judicial review. In interpreting state law in this area, state courts may not so exceed the bounds of ordinary judicial review as to unconstitutionally intrude upon the role specifically reserved to state legislatures by Article 1, Section 4, of the Federal Constitution. Because we need not decide whether that occurred in today's case, the judgment of the North Carolina Supreme Court is affirmed. It is so ordered. Justice Kavanaugh, concurring. I join the court's opinion in full. The court today correctly concludes that state laws governing federal elections are subject to ordinary state court review, including for compliance with the relevant state constitution. But because the Elections Clause assigns authority respecting federal elections to state legislatures, the court also correctly concludes that state courts do not have free rein in conducting that review. Therefore, a state court's interpretation of state law in a case implicating the Elections Clause is subject to federal court review. Federal court review of a state court's interpretation of state law in a federal election case does not imply a disrespect for state courts, but rather a respect for the constitutionally prescribed role of state legislatures. The question then is what standard a federal court should employ to review a state court's interpretation of state law in a case implicating the Elections Clause, whether Chief Justice Rehnquist's standard from Bush v. Gore, Justice Souter's standard from Bush v. Gore, the Solicitor General's proposal in this case, or some other standard. Chief Justice Rehnquist's standard is straightforward: whether the state court impermissibly distorted state law beyond what a fair reading required. As I understand it, Justice Souter's standard, at least the critical language, is similar: whether the state court exceeded the limits of reasonable interpretation of state law. And the Solicitor General here has proposed another similar approach: whether the state court reached a truly aberrant interpretation of state law. As I see it, all three standards convey essentially the same point. Federal court review of a state court's interpretation of state law in a federal election case should be deferential, but deference is not abdication. I would adopt Chief Justice Rehnquist's straightforward standard. As able counsel for North Carolina stated at oral argument, the Rehnquist standard best sums it up. Chief Justice Rehnquist's standard should apply not only to state court interpretations of state statutes, but also to state court interpretations of state constitutions. And in reviewing state court interpretations of state law, we necessarily must examine the law of the state as it existed prior to the action of the state court. Petitioners here, however, have disclaimed any argument that the North Carolina Supreme Court misinterpreted the North Carolina Constitution or other state law. For now, therefore, this court need not, and ultimately does not, adopt any specific standard for our review of a state court's interpretation of state law in a case implicating the Elections Clause. Instead, the court today says simply that state courts do not have free rein, and holds only that state courts may not transgress the ordinary bounds of judicial review. In other words, the court has recognized and articulated a general principle for federal court review of state court decisions in federal election cases. In the future, the court should and presumably will distill that general principle into a more specific standard, such as the one advanced by Chief Justice Rehnquist. With those additional comments, I agree with the court's conclusions that state laws governing federal elections are subject to ordinary state court review, and 2, a state court's interpretation of state law in a case implicating the Elections Clause is in turn subject to federal court review. Justice Thomas, with whom Justice Gorsuch joins, and with whom Justice Alito joins as to Part 1, dissenting. This court sits to resolve not questions and issues but cases or controversies. As a corollary of that basic constitutional principle, the court is without power to decide moot questions or to give advisory opinions which cannot affect the rights of the litigants in the case before it. To do so would be to violate the oldest and most consistent thread in the federal law of justiciability. The opinion that the court releases today breaks that thread. It affirms an interlocutory state court judgment that has since been overruled and supplanted by a final judgment, resolving all claims in petitioner's favor. The issue on which it opines, a federal defense to claims already dismissed on other grounds, can no longer affect the judgment in this litigation in any way. As such, the question is indisputably moot, and today's majority opinion is plainly advisory. Because the writ of certiorari should be dismissed, I respectfully dissent. Here is the case before us in a nutshell. A group of plaintiffs sued various state officials under state law. The defendants raised both state law and federal law defenses. In the interlocutory judgment below, the state Supreme Court rejected both defenses and remanded for further proceedings. We granted review to consider the defendant's federal defense. But then, in subsequent proceedings, the state court revisited defendant's alternative state law defense and held that it was meritorious. As a result, the court finally adjudicated the whole case in the defendant's favor, dismissing the plaintiff's claims with prejudice. This is a straightforward case of mootness. The federal defense no longer makes any difference to this case. Whether we agree with the defense, disagree with it, or say nothing at all, the final judgment in this litigation will be exactly the same. The majority does not seriously contest that fact. Even so, it asserts jurisdiction to decide this free-floating defense that affects no live claim for relief, reasoning that a justiciable case or controversy exists as long as its opinion can in any way alter the presently operative statutes of a state. By its own lights, the majority is acting not as an Article III court, but as an ad hoc branch of a state legislature. That is emphatically not our job. To review the history of this case is to demonstrate that the question presented is moot. In 2021, the North Carolina General Assembly passed an act to redistrict the state for elections to the U.S. House of Representatives. Plaintiffs' respondents filed an action in state court, seeking to enjoin state elections officials, defendants' respondents here, from conducting elections in accord with the act. They based their claim for relief on the North Carolina Constitution, which they argued prohibits excessive partisan gerrymanders. Petitioners, state legislators representing North Carolina's interest in the enforcement of the act, raised defenses under both state and federal law. As relevant here, they argued, 1. That partisan gerrymandering claims are not justiciable under the North Carolina Constitution, and 2. That the state constitution cannot restrict the General Assembly's congressional districting legislation under the Federal Elections Clause. Initially, a 3-judge trial court endorsed petitioner's state law defense and entered a final judgment dismissing plaintiff's respondents' claims with prejudice. But, on appeal, the North Carolina Supreme Court reversed that judgment. In Harper I, the court held that the 2021 Act violated the state constitution, enjoined its implementation, and remanded the case to the trial court for remedial proceedings. In doing so, Harper I rejected both petitioner's state law justiciability defense and their Federal Elections Clause defense. Petitioners then sought this court's review of Harper I insofar as it rejected their federal defense. From the start, they faced a significant jurisdictional question. Our appellate jurisdiction over state courts is limited to final judgments or decrees rendered by the highest court of a state in which a decision could be had. But Harper I was a classic example of non-finality. It was an order that resolved the issue of liability and remanded for remedial proceedings. Thus, under the normal rules, Harper I would not be reviewable by this court. Nonetheless, this court's precedents have recognized a limited set of situations in which finality as to a federal issue permits our review, even in the absence of a final judgment as to the case. In granting certiorari, we relied on one of those doctrinal exceptions, premised on the assumption that the federal issue in this case would survive, and require decision regardless of the outcome of future state court proceedings. As it turned out, that assumption was wrong. After Harper I, on remand, the trial court adopted a remedial districting plan for the 2022 elections. Petitioners then appealed that order, taking the case to the North Carolina Supreme Court for a second time. Initially, the North Carolina Supreme Court released an opinion applying Harper I and affirming the trial court's decree. But then, after granting petitioners' request for rehearing, the court revisited the crucial issue in this case, whether claims of partisan gerrymandering are justiciable under the state constitution. After re-examining the fundamental premises underlying the decisions in both Harper II and Harper I, the court held that partisan gerrymandering claims present a political question that is non-justiciable under the North Carolina Constitution. It concluded, this court's opinion in Harper I is overruled. We affirmed the 3-judge panel's original January 11, 2022 judgment concluding, inter alia, that claims of partisan gerrymandering present non-justiciable political questions, and dismissing all of plaintiffs' claims with prejudice. This court's opinion in Harper II is withdrawn and superseded by this opinion. The 3-judge panel's February 23, 2022 order addressing the remedial plans is vacated. Plaintiffs' claims are dismissed with prejudice. In short, this case is over, and petitioners won. The trial court's original final judgment in favor of petitioners, affirmed by the state Supreme Court in Harper III, represents the final determination of the rights of the parties in this case. Harper I has been overruled, and plaintiffs' respondents' claims for relief have been dismissed on adequate and independent state law grounds. As a result, petitioners' alternative elections clause defense to those claims no longer requires decision. The merits of that defense simply have no bearing on the judgment between the parties in this action. That is the definition of mootness for an issue. It follows that no live controversy remains before this court. For any case or controversy to exist here, petitioners must be injured by the judgment below, and we must be able to redress that injury by acting upon that judgment. But petitioners are not injured by the judgment of Harper I at all. nor could we redress any injury to petitioners by doing anything to it. Whether we accept or reject petitioners' Elections Clause defense, plaintiffs' respondents' claims remain dismissed. As far as this case is concerned, there simply is nothing this court could decide that could make any difference to who wins or what happens next in any lower court. That is the definition of mootness for an appellate proceeding. The United States understands this. So do the elections officials whose conduct Harper I once enjoined. So, too, do the plaintiffs' respondents who started this case in the first place. As one group of plaintiffs' respondents put it, there is no non-frivolous basis for jurisdiction here. The majority does not contest that the Elections Clause issue in this case was only a defense to plaintiffs' respondents' claims for relief, nor does it deny that Harper III overruled Harper I and affirmed the very same trial court judgment that Harper I had reversed, and it concedes that, as a result, plaintiffs' respondents' claims have been dismissed in full on state law non-justiciability grounds. Thus, the majority does not contend that its opinion on the Elections Clause issue could make any difference to the final judgment adjudicating all the claims and the rights and liabilities of all the parties in this case. That should be the end of the discussion. Because the question presented cannot affect the rights of the litigants in the case before us, we are without power to decide it. Nonetheless, the majority finds that the judgment below still presents a live Article 3 case or controversy. It then further concludes that the question presented has survived and requires decision under Cox Broadcasting. In doing so, it relies extensively on petitioners' representations that they remain bound by the judgment in Harper I. But of course, parties' mere representations that they are injured never carry their burden of demonstrating that they have standing in this court. Nor can such representations affect our independent obligation to assure ourselves that jurisdiction is proper before proceeding to the merits. To ensure that it has jurisdiction here, the majority must explain how petitioners' federal defense could still affect the rights of the litigants in this case. It fails to do so. Instead, mostly points to irrelevant facts about the procedural history of this case, and misapplies civil procedure rules as if Harper I and Harper III did not involve the same case. But the error that actually drives the majority's conclusion is much deeper. The majority evidently thinks that when Harper I held the 2021 Act unconstitutional, it entered a judgment affecting the 2021 Act as a statute, independent of its application to the legal rights of the litigants in this case. And the majority thinks that to reverse Harper I's judgment would negate the force of its order striking down the Act, thus altering the presently operative statutes of North Carolina. But of course, the judicial power does not operate on legal rules in the abstract. It operates on the rights and liabilities of contending parties with adverse legal interests. The majority's reasoning cannot be squared with the judicial power vested by the Constitution, the case or controversy requirement, or the nature of judicial review. I start by clearing away some of the brush. True, Harper III did not expressly revisit the Elections Clause issue. True as well, petitioners did not obtain rehearing of Harper I. But none of that matters, because Harper III's final judgment mooted the Elections Clause issue in this case by dismissing plaintiffs' respondents' claims on alternative state law grounds. Likewise, the idea that Harper III did not alter or amend in any way the judgment in Harper I is both irrelevant and incorrect. It is irrelevant because our jurisdiction requires a case, and this case is over no matter what becomes of the empty husk of Harper I's interlocutory judgment. It is incorrect because Harper I's judgment, reversing the trial court's original judgment and remanding the case, was completely negated by Harper III's affirmance of the same trial court judgment. In the same vein, the majority's suggestion that Harper I has any res judicata consequences is completely inapposite. Res judicata is the principle that a final judgment on the merits of an action bars relitigation in a second action of the same claim or of issues actually litigated and necessary to the judgment in the first action. Harper I was not a final judgment, as the majority concedes by applying Cox Broadcasting, so res judicata simply has nothing to do with it. Nothing decided by Harper I was res judicata in the second state court appeal. Nor would Harper I's interlocutory Elections Clause holding have any res judicata effect in a future action between these parties. At the risk of belaboring the obvious, the clearest proof that Harper I was not a final judgment is Harper III, which revisited Harper I's determination of a crucial issue in this case, overruled Harper I's determination of that issue, and affirmed the very same final judgment for petitioners that Harper I had reversed. How could petitioners still be injured, and what more could this court possibly do for them? The majority suggests that the interlocutory injunction issued in Harper I still harms petitioners, but that idea is untenable. To start, the majority overlooks that the injunction only ran against the conduct of defendants' respondents, the state officials who actually implement election laws, not petitioners as legislators. Next, the majority fails to consider what it would mean if the injunction is still binding. that defendants' respondents are liable to be held in contempt and put in jail if they ever implement the 2021 Act. Even though Harper 3 dismissed this suit's challenge to the Act as beyond the reach of North Carolina's courts, that idea defies both common sense and civil procedure. A court simply does not go on enforcing an interlocutory injunction and imposing contempt sanctions for disobedience after reaching a final judgment dismissing every relevant claim for relief. Rather, the interlocutory injunction, like all interlocutory orders, merges into the final judgment, fully adjudicating all the claims and the rights and liabilities of all the parties to the case. With the entry of Harper 3's final judgment, the life of Harper I's injunction came to an end, and it no longer has a binding effect on anyone. In any event, the majority's analysis plainly does not turn on the belief that any defendant remains liable to potential contempt sanctions and jail time. Instead, its animating idea, uncritically borrowed from petitioners, is that Harper I's judgment operated against the 2021 Act as a statute. The majority describes Harper I's judgment interchangeably as enjoining the use of the 2021 map and striking down the 2021 plan. It then reasons that reversing that judgment would negate the force of its order striking down the 2021 plan, thus altering the presently operative statutes of North Carolina, such that the 2021 Act would again take effect. The majority regards this aspect of Harper I's judgment as entirely independent of Harper 3 as final resolution of the claims in this case, and it finds its theory confirmed by a proviso in a remedial redistricting act, passed immediately after Harper I, stating that the 2021 Act would again become effective if this court reversed Harper I. In short, the case or controversy that the majority thinks is still before us has nothing to do with the parties' rights and liabilities on the claims asserted in this action. Rather, it is simply whether a particular legislative act, which Harper I supposedly made inoperative, will again be operative or effective as a state statute. This reasoning bears no connection to the judicial power of this court or the court below. Judicial power is the power to adjudicate definite and concrete disputes touching the legal relations of parties having adverse legal interests, by determining the respective rights and liabilities or duties of the parties before a court in a particular case. Thus, a judgment binds the rights of the parties in that case, and it awards remedies that operate with respect to those specific parties. In deciding any case, the court must ascertain and declare the law applicable to the controversy. This duty, in turn, implies the negative power to disregard an unconstitutional enactment in deciding the case. But this negative power of judicial review is now a power per se to review and annul acts of legislation on the ground that they are unconstitutional, to change or to repeal statutes, or to issue orders that operate on legal rules in the abstract. Courts of law simply do not render judgments that toggle statutes from operative to inoperative and back again, as if judicial review were some sort of in rem jurisdiction over legislative acts. Indeed, such a conception would contradict the most basic premise of judicial review itself. An unconstitutional provision is never really part of the body of governing law, for the Constitution automatically displaces it from the moment of its enactment. Thus, when a court holds a statute unconstitutional, it is emphatically not depriving it of any legal force that it previously possessed as an act. The court is only deciding a particular case conformably to the Constitution, disregarding a statute that cannot govern the case because it is already void. That is the classic explanation for the basis of judicial review set forth in Marbury and Bayard, and it remains from that day to this the sole continuing rationale for the exercise of this judicial power. The majority's theory thus fails twice over, both as a description of Harper I's judgment, and as an explanation of how any justiciable controversy could exist in this court. The only power that the North Carolina courts exercised at any stage of this case was that of determining the respective rights and liabilities or duties of litigants in the controversy before them. Harper I's judgment line did not read, "stricken down," referring to the 2021 Act, but instead, "reversed and remanded," referring to the lower court judgment and the case between these parties. The judicial power operates upon parties and cases, not statutes, and Harper I was no exception. Even if it were, we would still have no case or controversy in front of us. A freestanding judgment of statutory invalidation, neutralizing the 2021 Act in some manner transcending the final determination of the parties' respective rights in this case, would not be a judicial action within the meaning of Article 3, and it could not be reviewed in this court. We sit as a court of law, not a council of revision, and our powers of judicial review are judicial, not legislative, in nature. The only power that we ever could have exercised here was to modify the adjudicated rights and liabilities of the parties with respect to the claims in this action. Because we plainly cannot do so, no matter what we think about the Elections Clause, this proceeding is moot, and the idea that we could still decide petitioners' moot federal defense because it could alter the presently operative statutes of North Carolina, even if it cannot affect the ultimate judgment in this action, is wholly foreign to Article 3. In that light, The post-Harper I Remedial Act and its trigger provision plainly can make no difference to our jurisdiction or lack thereof. When passed, that act was essentially a change in the state's conduct under judicial constraint, the result of Harper 1, but with the declared intention of resuming the original conduct if that constraint were removed. That declaration kept the controversy alive while the constraint still existed. But, after Harper 3, there is no more constraint in this case. Harper I has been overruled, and plaintiffs' respondents' claims have been dismissed in a final judgment. Nothing about this case prevents the state from either enacting or implementing any districting plan. If the presently operative statutes of North Carolina need to be altered, that is the General Assembly's job, not ours. Regardless, petitioners have fully prevailed in this case, and plaintiffs' respondents have not obtained any enforceable relief that could affect the conduct of future elections. Indeed, to the extent the trigger provision adds anything to the majority's analysis, it only underscores the absence of a justiciable case or controversy. A state legislature is free to condition the effectiveness of a change in state law on external events, including this court's actions in cases properly before it. But, as should be obvious, such a trigger provision cannot be the entire basis of an Article 3 case or controversy, where, as here, the court cannot affect the adjudicated rights and liabilities of the parties in the case below. A state legislature cannot manufacture a justiciable controversy by providing that state law will change in some way depending on how this court answers a moot question. That would simply be a roundabout way of asking this court to render an advisory opinion. But federal courts cannot give answers simply because someone asks. That is true when the request comes from Congress, and it is equally true when the request comes from a state legislature. In sum, there is no issue before this court that can affect the judgment in this action. As such, the question presented is moot, and the writ of certiorari should be dismissed. I would gladly stop there. The majority's views on the merits of petitioner's moot elections clause defense are of far less consequence than its mistaken belief that Article 3 authorizes any merits conclusion in this case, and I do not wish to belabor a question that we have no jurisdiction to decide. Nonetheless, I do not find the majority's merits reasoning persuasive. The Elections Clause of the Constitution provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The question presented was whether the people of a state can place state constitutional limits on the times, places, and manners of holding congressional elections that the legislature of the state has the power to prescribe. Petitioners said no. Their position rests on three premises, from which the conclusion follows. The first premise is that the people of a single state lack any ability to limit powers given by the people of the United States as a whole. This idea should be uncontroversial, as it is the unavoidable consequence of the supremacy of the federal Constitution and laws. As the court once put it, in a case about the Article V ratifying power of state legislatures, a federal function derived from the federal Constitution transcends any limitations sought to be imposed by the people of a state. The second premise is that regulating the times, places, and manner of congressional elections is no original prerogative of state power, so that such power had to be delegated to, rather than reserved by, the states. This premise is firmly supported by this court's precedents, which have also held that the Elections Clause is the exclusive delegation of such power, as no other constitutional provision gives the states authority over congressional elections. The third premise is that the legislature thereof does not mean the people of the state or the state as an undifferentiated body politic, but rather, the lawmaking power as it exists under the state constitution. This premise comports with the usual constitutional meanings of the words state and legislature, as well as this court's precedents. A state, and the legislature of a state, are quite different political beings. A state, in the ordinary sense of the Constitution, is a political community of free citizens, organized under a government sanctioned and limited by a written constitution. Legislature, on the other hand, generally means the representative body which makes the laws of the people. To be sure, the precise constitutional significance of the word legislature depends on the function to be performed under the provision in question. Because the function contemplated by the Elections Clause is that of making laws, this court's Elections Clause cases have consistently looked to a state's written constitution to determine the constitutional actors in whom lawmaking power is vested. The definitions that most precisely explain this court's holdings were given in a state court case that anticipated these cases by several years. The word legislature, as used in the Elections Clause, means the lawmaking body or power of the state, as established by the state constitution, or, put differently, that body of persons within a state clothed with authority to make the laws. If these premises hold, then petitioner's conclusion follows. In prescribing the times, places, and manner of congressional elections, the lawmaking body or power of the state, as established by the state constitution, performs a federal function derived from the federal constitution, which thus transcends any limitation sought to be imposed by the people of a state. As shown, Each premise is easily supported and consistent with this court's precedents. Petitioner's conclusion also mirrors the court's interpretation of parallel language in the Electors Clause. The words, "in such manner as the legislature thereof may direct," operate as a limitation upon the state in respect of any attempt to circumscribe the legislative power. The majority rejects petitioner's conclusion, but seemingly without rejecting any of the premises from which that conclusion follows. Its apparent rationale, that prior cases have already foreclosed petitioner's argument, is untenable, as it requires disregarding a principal distinction between the issues in those cases and the question presented here. In those cases, the relevant state constitutional provisions address the allocation of lawmaking power within each state. They defined what acts, performed by which constitutional actors, constituted an exercise of the lawmaking power. In other words, those cases addressed how to identify the legislature of each state, but nothing in their holdings speaks at all to whether the people of a state can impose substantive limits on the times, places, and manners that a procedurally complete exercise of the lawmaking power may validly prescribe. These are simply different questions. There is a difference between how and what. This is not an arbitrary distinction, but one rooted in the logic of petitioner's argument. No one here contends that the Elections Clause creates state legislatures or defines the legislative process in any state. Thus, while the Elections Clause confers a lawmaking power, the exercise of that authority must follow the method which the state has prescribed for legislative enactments. But, if the power in question is not original to the people of each state and is conferred upon the constituted legislature of the state, then it follows that the people of the state may not dictate what laws can be enacted under that power, precisely as they may not dictate what constitutional amendments their legislatures can ratify under Article 5. Accordingly, if petitioner's premises hold, then state constitutions may specify who constitute the legislature and prescribe how legislative power is exercised, but they cannot control what substantive laws can be made for federal elections. The majority indicates that it does not perceive this distinction between substantive and procedural rules, illustrating its doubts with a rhetorical question. When a governor vetoes a bill because of a disagreement with its policy consequences, has the governor exercised a procedural or substantive restraint on lawmaking? The answer is straightforward. The power of approving or vetoing bills is a part of the legislative process, because it is a part in the making of state laws. A governor's motives for vetoing a certain bill are irrelevant to the effect of the veto as part of the legislative process, just as the motives that may lead one house of the legislature to reject a bill passed by the other house are irrelevant to the effect of its doing so. Put simply, when this power is conferred on the governor of a state, it makes him in effect a third branch of the legislature. This is a question of who, not what, and thus is a matter of state polity as far as the Elections Clause is concerned. But substantive constraints on what the lawmaking power can do, gubernatorial approval included, demand an entirely different justification, one that the majority never provides. It does not overrule prior cases to hold that the power to prescribe times, places, and manners for congressional elections is an original power of the people of each state, nor does it hold that the people are themselves the legislature to which the federal Constitution delegates that power. Indeed, the majority devotes little attention to the source and recipient of the power described in the Elections Clause, notwithstanding their direct relevance to the question presented. Instead, the majority focuses on the power of state courts to exercise judicial review of Elections Clause legislation. But that power sheds no light on the question presented. In every case properly before it, any court, state or federal, must ascertain and apply the substantive law that properly governs that case. Thus, the court naturally must apply the federal Constitution rather than any statute in conflict with it. The court must also apply the state constitution over any conflicting statute enacted under a power limited by that Constitution. Petitioner's argument, however, is that legislation about the times, places, and manner of congressional elections is not limited by state constitutions, because the power to regulate those subjects comes from the federal Constitution, not the people of the state. Right or wrong, this question has nothing to do with whether state courts have the power to conduct judicial review in the first place. To say that state judicial review authorizes applying state constitutions over conflicting Elections Clause legislation is simply to assume away petitioner's argument. The majority opinion ends with some general advice to state and lower federal courts on how to exercise judicial review in cases implicating the Elections Clause. As the majority offers no clear rationale for its interpretation of the clause, it is impossible to be sure what the consequences of that interpretation will be. However, judging from the majority's brief sketch of the regime it envisions, I worry that today's opinion portends serious troubles ahead for the judiciary. The majority uses the separate writings in Bush v. Gore as a loose touchstone for the kind of judicial review that it apparently expects federal courts to conduct in future cases like this one. On its face, this is an awkward analogy, for there is a significant difference between Bush and the present case. In Bush, the state court's judgment was based on an interpretation of state statutory law, enacted by the state legislature. Thus, the relevant electors clause question was whether, in doing so, the state court had departed from the clearly expressed intent of the legislature, impermissibly distorting the legislature's enactments beyond what a fair reading required. In contrast, there was no doubt that the state court in the present case departed from the clearly expressed intent of the legislature. It rejected the legislature's enactment as unconstitutional. By doing so, today's majority concludes, the state court did not commit per se error, as the Elections Clause permits state courts to apply substantive state constitutional provisions to the times, places, and manner of federal elections. At the same time, state courts are warned that they operate under federal court supervision, lest they transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. Thus, under the majority's framework, it seems clear that the statutory interpretation review forecast in Bush, or some version of it, is to be extended to state constitutional law. In this way, the majority opens a new field for Bush-style controversies over state election law, and a far more uncertain one. Though some state constitutions are more prolix than the federal constitution, it is still a general feature of constitutional text that only its great outlines should be marked. When it is a constitution courts are expounding, not a detailed statutory scheme, the standards to judge the fairness of a given interpretation are typically fewer and less definite. Nonetheless, the majority's framework appears to demand that federal courts develop some generalized concept of the bounds of ordinary judicial review, apply it to the task of constitutional interpretation within each state, and make that concept their rule of decision in some of the most politically acrimonious and fast-moving cases that come before them. In many cases, it is difficult to imagine what this inquiry could mean in theory, let alone practice. For example, suppose that we were reviewing Harper I under this framework. Perhaps we could have determined that reading justiciable prohibitions against partisan gerrymandering into the North Carolina Constitution exceeded the bounds of ordinary judicial review in North Carolina. Perhaps not. If not, then, in order to ensure that Harper I had not arrogated the power of regulating federal elections, we would presumably have needed to ask next whether it exceeded the bounds of ordinary judicial review in North Carolina, to find that the specific congressional map here violated those prohibitions. After all, in constitutional judgments of this kind, it can be difficult to separate the rule from the fact pattern to which the rule is applied. We have held, however, that federal courts are not equipped to judge partisan gerrymandering questions at all. It would seem to follow, a fortiori, that they are not equipped to judge whether a state court's partisan gerrymandering determinations surpass the bounds of ordinary judicial review. Even in cases that do not involve a justiciability mismatch, the majority's advice invites questions of the most far-reaching scope. What are the bounds of ordinary judicial review? What methods of constitutional interpretation do they allow? Do those methods vary from state to state? And what about stare decisis? Are federal courts to review state courts' treatment of their own precedents for some sort of abuse of discretion? The majority's framework would seem to require answers to all of these questions and more. In the end, fear that this framework will have the effect of investing potentially large swaths of state constitutional law with the character of a federal question not amenable to meaningful or principled adjudication by federal courts. In most cases, it seems likely that the bounds of ordinary judicial review will be a forgiving standard in practice, and this federalization of state constitutions will serve mainly to swell federal court dockets with state constitutional questions, to be quickly resolved with generic statements of deference to the state courts. On the other hand, there are bound to be exceptions. They will arise haphazardly, in the midst of quickly evolving, politically charged controversies, and the winners of federal elections may be decided by a federal court's expedited judgment that a state court exceeded the bounds of ordinary judicial review in construing the state constitution. I would hesitate long before committing the federal judiciary to this uncertain path, and I certainly would not do so in an advisory opinion in a moot case, where the only function remaining to the court is that of announcing the fact and dismissing the cause. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.